Hello, everyone, and welcome you to this amazing webinar today when we are discussing all aspects and different areas around the subject of freezing injunctions and interim protection. My guest here is Edward Miller from Madison Legal, who is an absolute expert on the subject, and it's a really good opportunity to discuss with him what are the legal repercussions in case that there is a freezing order against you, but how we can also implement that in a real life. What does it mean to us as individuals or even companies when there is a freezing order? What can we do? How we can find an alternative account if we can do that, and how does it affect our business? So this is what we are going to talk about today. Welcome, Edward, and thank you very much for being here today with us.
Thanks, Victoria. I'm going to start speaking about probably from the claimant side of things, of how one obtains a freezing order, but I think there might be some questions and discussions on what to do if you've received a freezing order, either as a defendant or defendant in the matter, or as a bank or third party. But it might be if you could do the first slide, so we can explain what a freezing order is.
And before we come into that, Edward, just share a bit more information about yourself, right? What's the story behind Madison Legal and what's your background? I think it's super interesting.
Where you're coming from. Madison Legal is a boutique legal firm. We're based in London. We solely do quite high-value, high-profile litigation and arbitration, and also insolvency matters, contentious insolvency matters. We're a growing firm. I say 3 years, actually into our 4th year now. 2021 we started, and we're doing a lot of matters for international arbitration, a huge, big insurance insolvencies involving multi-jurisdictions, a lot of offshore jurisdictions, including Gibraltar, which is one of our main contacts. We started with one of the partners, Daniel Featon, King's Counsel, was also a partner, a big firm in Gibraltar. So we try to get involved with a lot of Gibraltar cases with the English law side of things. But as a growing firm, we're dealing with lots of international frauds, international arbitrations, and cross-border insolvencies. And as part of that, and especially with the fraud cases, we get regularly instructed by claimants and defendants on both sides of the gate in relation to fraud cases. But in particular, when you have a fraud case, and I'll come on to it and do the topic, there is an element of a freezing order, or at least it's something a claimant's solicitor, plaintiff's solicitor should investigate with his clients. But I think it's now to get on with the topic. Before we get on to what freezing orders is the background of a case. As you all know, you've got a claim. Let's say, for example, it's worth $100 million US. It's the typical size of claims we do. You've got the claim, you've issued proceedings, and what you do to get to judgment. Judgment's not going to be till another 12 or 18 months, if not longer. So what you do, the ultimate aim of any claim on the claimant side is to get a judgment, an enforceable judgment. And what you do to do that, when you think that a party might be up to something, up to no good, there are certain interim measures one can do. If you can put the slide back on, I'll just go through a few of them before we delve into freezing orders, which I'll come on to that last. But there are various other matters you can do, especially they're all about when you think someone's going to dissipate either assets, or in the case of search orders or imaging orders, if they're going to destroy evidence. The one thing you can do is immediately apply to court and do something called a search order, whereby you get an order where you physically go around to the offices, usually of a defendant, and take clones, usually of computers, of phones, of anything digital, mainly. So you can get that because you have a suspicion that that party is going to destroy key evidence. And nowadays, everything is digital. Back in the days when it's boxes of documents where you would have to physically go in and take photocopies, etc. Now you can just take a clone of it and get something called an imaging order, where you get a specialist IT person actually go and clone remotely a lot of the time those documents and then compare the freezing. But you can just go back to the slide if someone wants to go through some interim measures. I'm not going to go through them all because each one of these are probably going to be another topic at some point, but simply because the title of this is interim protection. What to do if you're a defendant side and someone is, usually a company, is suing you and you don't think they're going to pay your costs or can't pay your costs at the end. You can apply for something called security for costs, whereby you would get an order from the courts whereby the claimant, and it's usually the claimant side, would have to pay an amount into court to protect you when you come to enforce costs. Not in relation to damages, we don't have that. There is a separate topic, there is something called security with damages in arbitrations, but we'll come on to that in another topic. Preservation orders are normally, if it's usually an asset like a house or property, real property, where you think they are going to dissipate that and change it into someone else's name, you can get interim orders to protect yourself and register against the land registry and protect yourself there. But coming on to the topic of freezing orders. Freezing orders are effectively freezing someone's bank accounts. Normally, not just their bank accounts, but normally it says a bank account where liquid assets can be transferred quickly, easily into different jurisdictions, usually an offshore jurisdiction, and you have suspicions that there has been some dissipation, or more important, there will be dissipation in the future. So, what is and how do you get one? So, requirements, and there'll be a few questions you can go back. Requirements, this is for an English case, and there'll be some questions I think about obtaining in foreign judgments or foreign support of foreign cases, but in the UK, is the court must have jurisdiction over the defendants. And normally, that's the defendants in the jurisdiction, if it's a company or an individual, or the locus of the claim is going to be in the UK. So the court is seized with the jurisdiction over that defendant or defendants. And that's another whole topic of whether the court is seized with it, but assuming they are seized with it, and if they're in the UK or it's a company in the UK, then normally the court will have jurisdiction. The second requirement is there must be a cause of action. You must have a particular legal case against the party, whether that's in a case of fraud, whether it's a case of some debt or damages. There must be an underlying cause of action in relation to that. Because we'll go on to it, it's not a freestanding order. You have to then prove later on that you are entitled to those damages. It's to protect assets that may be dissipated when it comes to enforcement. Third criteria is the assets normally should be in the jurisdiction and subject to the injunction. So what does that mean? That means that these are assets that you can enforce against later on. They're the defendant's assets, or the defendant has beneficial interest in them, not be in the defendant's name, but later on you can prove that those defendants would have those assets to be able to pay any cost orders or damages to you. And the fourth criteria is there's a real risk of dissipation. That means, again, future dissipation. That means that there is a real chance that if you don't do anything, that when it comes to enforcement of your judgments, and you spent 18 months spending millions of pounds getting your judgment, there'd be nothing left of it. So you would have to show and provide evidence there is some dissipation. I'll come into that, each of these in more detail. And the third one are just other points where it's just an inconvenience. I'll come on to that on the slide. If you'll do the next slide. So how does the court get its jurisdiction? And I'm not going to go into too much detail here because there's going to be questions, especially on case of broad idea, which is a Privy Council case. But there used to be that there was the cause of action in the UK for an English freezing order, that means it wasn't able to support a foreign judgment. If you got a judgment in, let's say, Gibraltar or the Bahamas or something like that, you have to have a cause of action in the UK for an English freezing order. Now, recently, the 2023 decision of the Privy Council is that there's the enforcement principle. As long as there's assets in the jurisdiction for doing it, and it can be based on a foreign judgment, so you don't need to actually do an underlying claim. It is based on foreign judgment.
Right. So can I ask if we can imagine this, that let's say I've got a company account, let's say in Belgium, in Nigeria, in Singapore, and if there is a court case coming up against me, then the court needs to alert all of these jurisdictions and issue this freezing case against me, because those are all managed by different countries, and then it obviously gives complexity to the case. How can we imagine this?
Yeah, I mean, normally when you're doing with frauds, the assets are usually in all sorts of different jurisdictions. So you can get a worldwide freezing order, which is normally what people get for fraud cases because of that jurisdiction. So you'll get a freezing order in the UK, for example, and then you'll then need to then serve it on any banks in the UK. Simply, and obviously they come under the UK's jurisdiction. But if the Nigeria and the other jurisdiction, Belgium, you'll then have to probably go to a local court to get a piggyback freezing order in their local court, and then they would then need to register it then and serve it on the local bank or the account or the third party. In the defendant obviously is compelled not to move those assets, but obviously the main thing that we don't want to rely on a fraudster breaching a freezing order. We want to enforce it by having a bank, freezing the bank accounts and basically making it difficult, which is simple, and you serve it on an English bank. But again, you'd have to, for a Nigerian bank or Belgian bank or whichever bank, you would have to then usually get a reciprocal agreement order in the courts of those countries and then serve it on them. And of course, different jurisdictions have different rules, and not all jurisdictions have the equivalent of freezing order. So it does become quite complex and quite difficult when you've got multiple jurisdictions. But again, your choice is left with do nothing and potentially have nothing to enforce against, or to go and spend your money up front to get those orders in the different countries and then serve it on the relevant third parties.
Got you. And I assume that there is a significant time frame involved in that as well, because by that time it reaches the local court. By that time the local court starts even working on that. Then maybe the fraudster has some opportunity to still move the funds around, right? Because the banks at that point are not alerted about that. So compliance going as business as usual. They are unaware that there could be a court case against my company in this case, and then I still have the opportunity to move the funds around. What's happening in this case? Obviously.
Yeah, I mean, one of the criteria is to draw freezing orders in general is to move fast, because obviously if there is a risk of dissipation, you need to, for two reasons. Practical reason, you don't move fast, then it might be dissipated. But also procedurally, if you wait too long, the court might say, well, there isn't a risk, or you've accepted the risk and we're not going to grant it, because it's a draconian measure. It's a measure before there's a judgment. So the judge hasn't made a decision on whether that person's guilty or not, or whether there's going to be a judgment against them, is in case they may do it. So very large, very draconian, very high level for the judge to actually look at and make that decision. So you need good evidence, but you do need to move fast on that. So in the UK, you can go, you could get instructed in the morning and you could be in court on the same day, and there'll be a 24-hour system. If it's that urgent, there's risk it's going to be dissipated overnight. Usually, you'll take a few days and sometimes weeks to even get the evidence in place to go to court. But that usually in different jurisdictions, the ones we've dealt with, like the common law jurisdictions, there is a similar process where you'll be able to go to court very quickly. But I mean, I would say if you're a claimant, the best thing to do once you've got your worldwide freezing order is to just simply send it to the bank in whichever jurisdiction, who may, they're probably not bound by it, there's no jurisdiction, but they may do a temporary freeze of the account anyway, and that might buy you some time. Obviously, for them, they're not bound by a UK court's decision, a Belgian bank or Nigerian bank, but usually their compliance department might consider there might be some frauds at play and might put their own sort of freeze on it, or obviously for a short time. So that will buy you some time. But you do need to move quickly, because if it is moving around, then you've lost those assets.
Yeah. All right. Thank you. Thank you. Let's go back to.
Yeah. So if you want the next slide, I'm not going to go into too much of the case details, but this is what a good arguable case means. It doesn't mean the judge is making a decision. You've got a slam dunk case. It's an absolute no-brainer. He's saying that basically you've got it. In layman's terms, it's about a 50-50 chance, just on the evidence. You've got a case that holds up in law. There has to be a legal basis for it in that jurisdiction, but also on the evidence that you, more likely than not, when this goes to trial and you've got disclosure and cross-examination, you are going to get a judgment in your favour. So it's good arguable, but usually, if you can show that there's a case in law and you've got some facts to fit around it, that will pass that hurdle. So, for example, if there's no legal basis for a claim, because there is a defence to it, or there's no course of action in whichever jurisdiction you're in, you're not going to get a freezing order. If I can go back, it's beyond another slide, but also I should say the procedure of these are done on an ex parte basis, meaning you're going in because of the urgency, and B, you don't want to tip off the other party, defendant, that you're about to get it. They're done on an ex parte basis, meaning you are there without the other party. So as part of that, in the UK, you need to provide full and frank disclosure. And full and frank disclosure basically means if there's something that doesn't help you, you have to disclose it to the court. Normally you dress it up and you explain it and you say, and you get instructions on how you can overcome it and persuade the judge to overcome it, but you need to make that available to the court. For example, off the top of my head, someone's saying someone's got a debt, and they're going to say, yes, we will pay it, but we need more time. You might need to disclose that, but then explain it. If you don't explain it, then the other party can then apply to set aside the freezing order later on the line.
Tipping off is an illegal activity, right? So for
when I say, I don't mean tipping off as in a popular proceeds of crime tipping off. I mean tipping off as alerting the other party that you're applying for freezing order, because so then immediately before they get the freezing order served on them, they transfer their funds to an offshore bank account in the Bahamas or Bermuda or somewhere.
That's right, but it's illegal, right? So if there is any kind of proven document which shows that I was alerting someone before the freezing order hits them to help them to move the assets out, then I have some legal responsibilities as well, don't I?
Yes, if it's served on you, so you got your freezing order, once it's served on you, or a third party for a bank, for example, or it could be someone with a benefit who's the legal owner of a property, and you say that the defendant is the beneficial owner. Once that's served on them, if they then assist with breaching the freezing order, then they are in breach of the South freezing order, and come on to it. There is a penal notice, meaning it'd be contempt of court, which some people don't care. Obviously, if they're in the Bermuda, they might not worry about having a contempt of court in an English court, unless they travel to the UK, when they could then potentially get arrested. But normally, that's why banks will obviously not breach them knowingly, but it's only until you're served with a copy of it. So that's why you don't want to alert the other party, because once you alert the other party and they've dissipated those assets, they're not going to get any repercussions from penal notice and the contempt, because they're non-physically got served. It might then have evidence of them dissipating further, and you can go back to court, but at that time the assets are being moved. So go on with the risk of dissipation. So as I was saying, this is showing that once you get a judgment, that there's a real risk that those assets are going to be dissipated, they're going to be put on an offshore account, they're going to be put in someone else's name, they're going to be spent, or they're going to be hidden somehow. And normally for fraudsters, they are adept at hiding assets or putting assets out of the reach. But you have to show that there is a real risk of future dissipation. And that's future dissipation. If there's evidence they've done it in the past, that might be evidence to infer to a judge that they'll do it again, but it's not definitive evidence that they will do it again in the future, just because someone's done something in the past. It might be evidence of an inferral, but it's not strict evidence they will do it in the future. And the other party might, when it comes back to court, the other party might be able to explain that was in the past, that's years ago, there's no evidence in the last few years. And we had quite a big case of about 2.5 billion of assets. We were on the defending end, and the client's evidence was, yes, that's happened years ago. I've got no evidence. There's no evidence that I'll ever do it again. I can explain it, and that's common knowledge. So the judge was with us on that point. But it's all about evidence, and it's evidence. Normally, it's cogent evidence of houses being swapped around in people's names. If the person tells you that they're going to dissipate assets, you have to have some evidence it's going to be put outside your reach, or to make it harder for you to enforce against by putting it into an offshore jurisdiction, even if it's in their own name. One of the criteria the judges might look at is how easy and costly it is if they are putting it into a bank account in Russia, for example, which we've had in the past. So as I say, there has to be future dissipation, and it's a circumstance of the case. So you just need to show to the judge that you, on the balance of convenience probabilities, you can show that they're going to do it in the future. And as I say, we'll come on to, once you've got that on the ex parte and the return date, so that there can be a response back on the other side.
And I guess it's very subjective as well from the judge's perspective. I mean, obviously he's got all the evidence, and there should be, a conclusion of what decision needs to be made based on those evidence. But there's a lot of subjective elements to it, right? So the judge might feel that there could be an opportunity for recurrence, and that's why they make a decision which could be stricter than perhaps the evidence shows, right?
Yes. I think as long as there's evidence in there, I think the judge will err on side of caution and grant, as long as the other criteria are met, will grant a freezing order, because there is a return date, which usually happens a week or two later. A return date basically means that the other party is an inter partes application. You have to make an application to continue the freezing order, and the other party would then be able to then give evidence of why the freezing order should be set aside or should be varied in the different levels, etc. The judge, normally on the ex parte application, when you've got one side, as long as there's some evidence, will probably err on the side of caution, because he or she is wrong on that, and those assets are dissipated. It doesn't matter if there's an appeal point, because at that point the assets are gone. It's very difficult. So normally when it comes to the inter partes application, so with the other party there, they will, and obviously they have counsel for the other party as well, they will look at it and probably look at it more fine detail. But having said that, the judge will also be asking questions of you, making sure that he or she doesn't want to get it wrong as well for the other party, because the access to justice means that this, even if it's for a few weeks, means they're going to have very difficulty accessing all their funds to pay legal costs, to pay the rents and everything they need. Yeah, so I think we've touched upon it, but if there's a fraud case, it's obviously easier to show, or there's evidence of fraud. It is easier to obtain a freezing order, because the judge will look at that, and he or she is not going to make a decision whether there has been fraud, make a decision of whether there is potential fraud in the background, if you pleaded fraud or not. I would touch on caution. It's not for for this webinar, but we've often made decisions not to plead fraud against a party deliberately when they've got some insurance in place, and when you don't know if the party's got if they got any assets, or they got an insurance or assets that will cover the judgment. Because once you do get a finding of fraud, it can invalidate that insurance cover. It's usually for directors and officers insurance, and if they got a coverage of a few £1 million within that, you as a claimant might not want to particularly plead fraud because you're actually doing yourself out of a potential asset you can enforce against later on. But that's a side note for another webinar.
Right. Just to quickly touch upon that. So basically, it's a public liability kind of insurance, right? Or it's a different kind of insurance.
No, I mean, normally, well, not all, a lot of directors might have directors and officers insurance, which will cover not only cover their legal costs of defending a claim, but might cover a possible if there's any damages.
Right, even if they are participating in the fraud themselves, because that's the whole point.
Well, that's what I'm saying. If there's a fraud, if you plead fraud, then and there's a finding of fraud, then the insurance company, as any insurance company, they want to try and get out of paying us, obviously. So if there's a finding of fraud against their customer, their insured, then that might invalidate the insurance. So you wouldn't be able to then claim against the insurance company, or the insurance company would not pay you as the claimant out. So you have to be wary sometimes. It's not always the case, and it's a case-by-case basis. And we at Madison, we also like to strategize from day one, and strategize where do we want to get to, how are we going to get there, what's the best option, the quickest option, the cheapest option, or what was the best option, value for money option to do from day one. But the freezing orders are slightly different because you are thrust in, because you need to get to courts within the next few days if you think they're going to dissipate in the next few days, or as I say, even overnight. So, there's some sleepless nights for people on those, or long days.
Oh, wow.
So assets. So I've been talking about what are assets. These are the obvious assets such as houses, paintings, bank accounts, vehicles, etc. All those can be covered by a freezing order. So you would get the freezing order, you would serve it on party. If it's a bank, that's very easy, you would serve it on the bank. If it's a property, you would serve it on the claimant or anyone else who's got beneficial interest in it. Paintings, anyone, a custodian who might be there, if it's in a museum, anyone in there, but you would serve it on them. But there's also chose as an action. That basically means whether the actual defendant has their own action against a third party. Effectively, if they can sue someone else or something else, you might be able to freeze that asset. If there is any money coming in, it will go to, well, it will be frozen and it'll go to you as the enforcement later on. There's the right to draw down loans. In the case, I won't go into it, but this case mentioned on here, the Avalova case, the right to draw down loans. If you've got a right, so it's not your money, but you've got a loan involved, and you've got a right to draw down, the defendant's got a right to draw down, it can be frozen against that, and that can be particularly useful for claimants to stop a third party effectively funding their litigation, funding their legal costs. So you would serve it on the parties giving the loan, the lender. And also, shares in companies, and now the case of Parsons, crypto, and I'm putting assets. I'm still not undecided whether those are assets in the strict sense, but they will be covered. The difficulty with this is, again, when you're serving on, you probably serve that on an exchange. So there people do it. Obviously, you serve it on claimant, the defendant, but the exchange, but they're notoriously bad for responding. They're not like a bank. They're usually in some offshore jurisdiction, so it can be very difficult and quite expensive to go and get there. If you want to enforce it properly, you would need to get a reciprocal order in whichever jurisdiction the crypto exchange is in to make sure they're not doing it. But a few of them, some of the big ones like finance and the big ones, if you serve on them, they will probably freeze it anyway. at least internally freeze it, whether it's binding on or not. At least that, until you can get a reciprocal agreement in the jurisdiction. I mean, just the convenience is, I'm not going to go into too much detail on that, but effectively, this means it should not cause unnecessary and disproportionate hardship to defendants. The quotes from that, and effectively, that means obviously a freezing order is a draconian order, and it's done before pre-judgment, but it shouldn't cause too much hardship. And I think the question about what you can actually pay out once you've got a freezing, once you receive a freezing order, and that's bank account. If you've got money, you'll need money to pay your rent, pay your mortgage, doctor's appointments. So you shouldn't be able to freeze absolutely everything. There's a subject to an exception I'll come on to later, but you can do the next slide. So practical points. So I've told you what a freezing order is and jurisdiction. I'm not going to read all this with 70 slides you need, but as I said, it's a ex parte application. You need full and frank disclosure. You need to show the bad and the good to the judge and persuade the judge that all these points are in your favour. There's more likely risk than not, based on the course of action, but also on whether the balance of whether you've got that 50-50 percentage and the judge in their mind is going, yes, you've got a better case than not. But also whether there's dissipation, if there's evidence that they've dissipated it, or you've known about it for a while and you haven't done any stuff with your hands. As I said, it's one of the criteria a judge might look at, is that you've known about it and you've accepted it, so I'm not going to do it. So you have to give all that ex parte, you have to give that full and frank disclosure. As I say, you need to act quickly, obvious reasons, and potentially you might need to give a cross-undertaking in damages. And what does that mean? Cross-undertaking, as I said, this is a order pre-judgment. So the judge has looked at the merits on the papers. There hasn't been disclosure, there hasn't been witness statements, there hasn't been any evidence in court. And he or she is making an order to freeze assets. And it does cause hardship, despite the previous slides. So you might need to get a cross-undertaking damage to the court, and that's an undertaking that if, when it comes to the final judgment, there was no claim and you weren't entitled to damages, and that obtaining that freezing order has caused hardship or damage to a company's business, to a company's account, you might then face a claim against you as the claimant, given that undertaking, to pay any reasonable or any reasonable damage that the freezing order and freezing all the assets, including the house. Maybe the house is sold, and maybe they were going to sell it. Maybe they've lost money on the sale. Maybe the value of a business has gone down. That time you might then face yourself with a claim against you. And you'd have to give not only evidence of that cross-undertaking, you'd have to give evidence potentially of your assets to show that you can pay assets. And if you can't show that, you might have to put money into court to show, if that, for them, it's called fortification for them, defendant to then go to court and just get that money from you.
I think it could be very complex as well, because if there is a freezing order against you, you can't even pay your suppliers, so your technology provider, your software provider, your employees, and obviously that is going to cause significant damage to your business, which cannot be even put in numbers, because that alone can easily kill a business nowadays in this fast-paced environment, even within months. So is there when there is a company which is getting a freezing order, is there any logic that the judge normally follows, that if it's for employees, not to harm the individual who are just depending on that company? For example, the salaries are automatically going, or for example, the major suppliers who also obviously need to pay their employees, for example, the software provider, Amazon Web Services, everything which is a basic need, then it can be paid out, or even those are usually subject to certain discussions.
Well, I mean, it wouldn't only just be if a freezing order is against a company. It could be an individual who's got a company that's outside. So they're not the company's not the defendant, but it's a company that's owned by the defendant. But normally there's a carve out to pay normal, usual business expenses. So you would, on the return date, I've mentioned, when you come back to court, the defendant has two choices. One is to turn up to court in the first place. Two is to try and set aside the freezing order, so it shouldn't be made because there isn't a course of action, there's no risk of dissipation, or you breach the full and frank disclosure requirement. So it should be set aside as if there was no freezing order. Obviously, in a couple of weeks since the return date, it would have been frozen. But they might apply to set aside, say, well, I've got company X, Y, and Z, or I am company, the company's the defendant in this matter. So we've got our suppliers, we've got employees, we've got these contracts we need to pay. You would have to then, as the defendant, or the company the defendant owns, would have to then provide evidence of what those normal business expenses were. So as long as they're normal business expenses or liabilities that need to be paid, the court will usually allow those payments to be made. But it's all about evidence. So you would have to, as the defendant, you'll need to prove those are the normal ones. That's usually done by, again, your accounts, maybe something from an accountant, or any evidence to show they are liabilities and expenses that you normally incur and have done for, 6-12 months beforehand. You've not suddenly come up with all these extra, contracts. And obviously, when you're dealing with fraudsters, they come up with all these fake contracts and etc. And liabilities and invoices that say need to be paid. So you have, as the claimant solicitors, you need to obviously scrutinise all that evidence. But in general, as long as they can prove it, there'll be a carve out for normal business expenses of a defendant company or a company that belongs to a defendant.
Got you. And I guess the complexity is now on the bank, when the bank needs to decide case by case based on the type of expense what the court allowed to be paid or it cannot be paid. So I assume it's a massive new burden on the bank or the financial institution itself to be able to execute those, particularly for those kind of cost types, right? Because then obviously the bank has to take the responsibility of allowing certain transactions but not allowing some. So the compliance department has to be heavily involved, which is obviously cost, time, headache for the financial institution. So is there any way to even, remunerate efforts of the financial institution when they've got a list of, you can allow these, but you have to restrict these, and good luck to figure out what's what kind of efforts?
Yeah, normally when you serve a freezing order on bank accounts, there might be, they usually charge you as the claimant a small amount just to do it, but it's only hundreds of pounds. You claim for millions, it's a cost. In terms of general compliance of it, normally bank would have to pay for that. You wouldn't get that. They might be able to claim it back from its customer, but you would have, when it came to that, and when you're drafting the amended freezing order, and you've got the carve out of what you're allowed, you would probably carve out specifically to make it clear for everyone, including the bank, what payments are allowed. But they don't need to make an inquiry on that. For example, the question, are you allowed to pay your living expenses and your legal costs? The bank wouldn't have to inquire whether those costs are legal expenses, but the claimant would be duty on the claimant to inform the claimants, so the defendant to inform the claimant solicitors what they've spent, so they can monitor it. So normally on a normal freezing order on an ex parte basis, it would say reasonable legal costs as a carve out, because a defendant would be allowed to obviously get the access to justice, or they must have be able to access funds to see, consider whether they want to apply to set aside or even defend the case later on, the actual underlying claim. But living expenses, normally you put a figure of probably £5,000 to £10,000 a month for an individual. I'm talking about an individual here, rather than a company, which is separate. And an individual might go back to court and say, yes, I can't set aside a freezing order, but my rent in Mayfair in London is 5,000 to 6,000 a month. I got this, I got that, I got daughter's private school, etc., etc., and you might be able to vary that. As long as those costs and those expenses are proved as normal living expenses that have been incurred over the last few years or so, then the court will usually increase the living expenses. And as long as the bank's got that, the bank won't have to inquire with their customer where that's part of it. It's for you as the defendants to make sure you don't breach it, or the defendant's solicitors make sure that's not breached. And for the claimants, once they get, they'll have to let the claimant solicitors know what legal costs have been incurred, and they can make a decision. If the legal costs only come to £500,000 in 1 week, there might be issues where you have to go back to court, and the law firm is caught up in this, or there's something going on. So you do need to, as the claimant, you do need to monitor and police the freezing order when you go along, and for the defendants to go back. And the defendant also, if there's a change of circumstance later on, they might be able to go back to court and vary it about the case and set it aside later on.
I'm just thinking about how practical it is nowadays when everything is automated. So obviously, when you're making a payment, you're not talking to a person who is subjectively deciding if that payment can go through or not. So what's the level of difficulty that the bank or the financial institution need to implement in those payment order systems, which are fully automated, that yes, this can go through, no, this cannot go through, or it has to be monitored by a person for this specific company for every single transaction, which is obviously going to incur some costs. So that's a big question, that how do you implement that technologically as a bank or a financial institution? How can you still not break the law? And obviously you're taking responsibility in case that one of the payment slips through the system, right? Oh, what was this payment? It's a couple of million for a marketing services of your cousin's company, right? And obviously there is a bit suspicious. But what is the level of responsibility of the bank in case that there is some mistake happens, and what are they required to have in place technologically to filter this out? Is there anything in the law for that, or is just decided by the financial institution, right? Because Singapore might have a different system, then Nigeria has a different system, then Belgium has a different system. So how that could work in practical terms?
Well, I mean, if it's a simple one, such as, you got £5,000 a month, for example, for living expenses, the bank should make sure. I mean, the difficulty comes when there's different bank accounts, and obviously each bank account, they're probably not talking to each other, but normally they've got a system in place to monitor that, because if they're served in it and they've got jurisdiction, if it's a UK bank, or you've got a reciprocal agreement in Belgian bank or the Nigerian bank, they usually got systems in place to make sure they're complying with those freezing orders. Because if they don't, then two things: one, they could be in contempt of court, or directors could be in contempt of court, and secondly, there might be a claim from the claimants if there is if there's not enough damages at the end, or not enough assets at the end to enforce it, and the bank has made a mistake. There could be a claim against the bank for not monitoring it. So I think it's a cost of business of banks to monitor it. And normally, if UK banks are normally very good, and they've got departments, the ones we deal with, they've got their specific departments who are dealing with that. And I'm sure there is some system of talking in between the banks of monitoring. But this goes back to the claimants, who make sure once the claimants, so the defendants, confirm what they paid each month, and then they're complying with it. Then they're to police it to make sure the defendant hasn't done it, and then go back to them. And normally, if there's a law firm doing it and advising them on that, obviously you can't, as a lawyer, you can only give advice. You can't physically stop someone doing it, unfortunately. But there should be a system in place. Obviously, it's not perfect. We've done it before, where we found out someone has breached freezing orders to pay legal costs and get loans in place, etc. Or they haven't declared their assets, because the one thing once you get the freezing order, you also usually normally have to declare all your assets worldwide over a certain amount of money. So you should be able to monitor it then. And once you've declared they've declared those assets, and that's normally done within about 48 hours. You're supposed to give an affidavit that you then serve it on. Or normally, if they've complied with it, then there should be ways and means. It's the case when they don't comply with it and having evidence that they've not complied with it. And it's not a foolproof system. It is an incentive for someone not to breach it as a claimant. It's an incentive for a bank not to do it, but obviously things can happen either deliberately for the placement of a defendant or mistakenly for a bank. But they should have robust procedures in place. I can't talk for different jurisdictions, but a UK bank would be in serious trouble if they knowingly or negligently allowed monies to go out to the accounts and breach of it. I mean, I think a practical tip to do would be for the solicitors and defendants to come up with a good order to set out exactly what payments should be made and when, and if they're business accounts, if they're different business, and put that in the order itself.
Clear. Yeah, I'm just thinking about, the smaller fintechs, smaller financial institutions who try to cut costs. Obviously, there are a lot which are developing their own system in-house, and maybe that's because this is not really a common case. It might be, slipping through their robust system, because obviously banking with legacy systems, they have it. Just smaller wallet providers, for example, or smaller financial institutions, it could be a problem. All right.
No, I mean, I would suggest if a smaller fintech company or smaller bank, if they are served with a freezing order as a third party, that they might want to take local legal advice in relation to it, so they don't inadvertently breach it, and then they could, as I say, could be in contempt of court, and we have a claim against them. So they should monitor it, closely and get the relevant advice. And obviously, once they've had a few of these, they should implement systems and have compliance systems in place.
That's a golden advice, because that's usually no one thinks about it until the problem hits. So it's a good thing to keep in mind.
Right, yeah, especially if they don't feel they're the defendant and it's someone else, obviously. And as you say, a defendant, you can't rely on the defendant giving you the true picture. But as long as obviously they got a system in place. And the third thing, obviously, it'd be harder for someone to sue a smaller one if it's developing, and a bigger bank should have bigger systems and more money in place. So there are get out of jail arguments in there, but you don't want, if you can avoid it, then I'd say take advice. That might be general advice. It might be worth, even as they're developing and they're getting bigger, to get advice on what happens if we get a freezing order through the door, not when we get a freezing order. To sort of fire test some of these scenarios and maybe get advice then and develop their systems before it happens and put systems in place. Domestic versus worldwide freezing order. So normally a freezing order, because it's such a draconian measure, normally it is, for a UK freezing order, it is a domestic freezing order. So you'd have to have assets in the jurisdiction. But, as I said out here, if there's not assets or not sufficient assets, if the claim's worth 5 million and there's only a house that's worth $500,000 in the UK, but there are assets, you've got a house, the defendant's got a house in Spain and a company in Cyprus, etc., you then should show evidence to the court that there are assets, that known assets, that that the assets are outside the jurisdiction. But if the claim is worth £1 million and there's a house that's worth £5 million in the UK, then the courts are likely to grant a worldwide freezing order because there's sufficient assets in the UK. For obvious reasons, it's only to protect the amount of the claim or purported amount of the claim, not all the assets over a certain amount. So you should show, as a practical point, if you know there's a property in the UK, you should try and get some sort of survey, even if that's a desktop survey for the amount, and then show to a judge that's only worth £500,000, my claim is worth £2 million, for example. but there's an asset in Cyprus. There might be issues where you don't know where the assets are, but you suspect there's assets, you don't suspect there's enough assets, or you don't know there's assets, so you might be able to persuade the judge that it should be a worldwide freezing order. And as I say, once you get that order, they'll have to disclose their assets worldwide in any event, and you might need to convert a domestic freezing order into a worldwide freezing order later on, once you've got their assets, and also the assets in multiple jurisdictions. But again, going back to if there's enough assets in the jurisdiction you're in, the judge is unlikely to grant a worldwide freezing order, and frankly, there's no point, even from the claimant's point of view, because it's costly and you'd have to get reciprocal agreements and monitor it. So as long as but it's all about the evidence of what assets there are in each jurisdiction. Yeah, I think
that's also something I wanted to ask you. That let's say that there is a company which is committing fraudulent activities, and there's a freezing order against them. For example, the financial institution where the license has been revoked and they shouldn't operate, but they do. Or there is an intentional wrongdoing of, for example, I don't know, any kind of activities, whatever, gambling, casino activities without the local license, obviously doing something wrong from the get-go, and then there is a whistleblower, there's a problem with the company. So these freezing orders, I assume, can be applied for companies just to defend the customer deposits, because these companies could hold funds on behalf of individuals or other companies, third parties, and those might be in danger. So in case that there is a freezing order obviously for individuals who got living expenses and the daughter goes to private school and whatnot, that's clear that what are the living expenses. But if this freezing order is against the company, and of course the directors as well, but it's a different story, but the company itself, then what could be justified in this way of, like, the company obviously has to shut down, but how do the existing providers get paid out, and how individuals whose deposits is still there? For example, we've seen so many times that there is an issue with a bank, the bank goes down, we need to wait 1 year until we get back the money as individuals. Did you have any case on that, or can you tell us a bit more on that?
Yeah, I mean, it depends who's applying for. I mean, on that case, it might be in the UK, it might be the FCA or someone who's doing it, sort of the regulator, if they haven't got a license, who's applying for the freezing order. And obviously the exception, if there's good evidence that they're doing something that is breaching the regulations, they probably wouldn't be allowed to continue paying those business expenses, because to do so would be, again, endangering the assets. I mean, what you'd probably suggest in those ones, if you feel like you've got a cause of action, and you could trace those funds as an individual, or even the FCA in the UK, or whichever regulator, whichever jurisdiction, could trace those and make an action on behalf of consumers or investors, and to trace those funds because some illegal activity going, you might be able to obtain something called a proprietary injunction, which a proprietary injunction is slightly set. Normally, you might do the same with a freezing order at the same time, but you might want to apply for that to say, well, these are my assets, and I can trace it from me to them, and for them to do it, to continue trading is going to dissipate those assets, or going to lessen those assets, or an issue that might be shut down. But I can trace those particular assets to me, and I'm going to apply for a proprietary injunction. A proprietary injunction, slightly different than the freezing order, I think strictly needs any issues of dissipation. So all you need to show is that is your funds, or persuade the judge it's more likely not those are your funds, and you can trace it in there as some illegal activity. So those funds are frozen, and they can't even use those for legal costs or living expenses or business expenses, because doing so is using your funds to pay their own legal expenses. Right. It gets slightly tricky where there's money in banks, because it's not necessarily whether that is actually evidence of if that's your funds or it's a group of funds and who's that. But obviously, if it's coming from a regulator and it's on the behalf of multiple investors or all investors, that's less likely because you're freezing everything and not just one individual. But where it's more assets that you can trace or non-cash assets, where it gets mixed up and gets more complicated, you can get the proprietary injunction. And normally you might even get the injunction both together and try to get both a proprietary injunction and a freezing order then. But the slight difference again is that that's your money, or you say that's your money or your assets, and they should not be using that for anything. That's probably the way to go. Obviously, it's all case by case cases.
And I assume that it's very hard to, and I assume it's very hard to determine the jurisdiction as well, even with the regulator, because if there is a company which is operating, worldwide and it's holding deposits from various depositors, maybe for the defending of the UK customers, there has to be a UK jurisdiction and the UK regulator, but in Europe, the European one, and then, outside of Europe, the local jurisdiction apply. In this case, what happens? Like, who takes the lead in case that, multiple jurisdictions gets involved in that and need to come to a conclusion of like, okay, we need to summarize who is going to take the lead and lead this?
Yeah, I mean, one would hope there'd be some discussion between the regulators, but that's not always going to happen. But normally, the person who takes the lead, or the regulator, or the individual who take the lead, where the course of where the actual claim will be brought. So, for example, if it's a UK regulator and the assets are in the UK, and the actual legal case we run in the UK, it'd probably be the UK regulator. Or if there's assets or bank accounts in different jurisdictions that belong to that the wrongdoer, then you might need to get reciprocal freezing order or proprietary injunction in that jurisdiction. So to say it another way, if the case was being run in the BVI, it was a BVI company, the BVI courts had jurisdiction because it's BVI, but there were bank accounts in the UK. But the case was being issued, it's been run in the BVI. You can go to the UK courts and get a freezing order in support of those foreign case, the foreign claim that's going on, because obviously the freezing order, you're only freezing assets in whichever jurisdiction you're in. So you run the case in the BVI and then get the judgment, etc., or either get the judgment and then get the freezing order, or run and get the judgment in there, but get a separate freezing order, standalone freezing order in support of foreign proceedings in the UK, for example.
Right. Okay. And then it also applies, let's say that, for example, I'm a Cypriot individual. I'm dealing with an asset management company, let's say from the Cayman Island, who's got a bank account in the UK. But in our terms and conditions, it's written that in case that there is any kind of, or, the terms and conditions says that the court has to be in, I don't know, Singapore. So that can be really complex, and then it's based on the agreement, right?
Potentially, yes. I mean, there's ways and means that they might challenge jurisdiction later on, the defendant. But just if there's a fraud case, for example, or you're claiming against directors who are you're not claiming against the company, the directors have done something fraudulent or third party, or there's some impropriety, some description. You're not relying on the terms and conditions. You're relying effectively where the loss is happening, and the torts, or whatever it is, like conversion, it might be theft, etc. But where the loss happens. I mean, going into jurisdictions are another big seminar on its own right, but there's not necessarily what terms and conditions say, especially if you're pleading fraud, because you're outside that thing. It's not a breach of contract. It's something gone beyond that. I mean, not to say they won't challenge jurisdiction later on, but it'll be harder for them to challenge jurisdiction, the freezing order, or the case in general later on if you're pleading fraud.
Got you. What happens in case that there are nominees involved? Because it's a very regular and a very common thing that you incorporate a company and then you appoint a company as a nominee, or a local individual to act as a nominee. In case that this happens, whoever's name is on the paper is the one whose assets are going to get frozen, Or is there any further discussions to say, no, I'm just a nominee, I agreed, and this is the agreement, and this is the real, for example, director or even whoever is the director of the company who acts as a nominee director? What's happening in this case?
Well, if they're holding assets or controlling assets, doesn't mean they have to control or hold assets on behalf of the defendants. They could be caught up within the even though their name's not on the actual claim itself, as long as they're there. But you would have to obviously serve those, or the director of this, if there's various shell companies or various companies within a group, you might need to serve those companies. I mean, there's also companies might be claiming against an individual, but that individual owns a property for a BVI company, for example. You then have to serve the BVI company and potentially get a freezing order in the BVI to get the jurisdiction in relation to that. So, but it's not the company you're suing; it's the individual. But that nominee or that company got holding or controlling assets on behalf of the defendant.
Right. And what happens if someone gets very creative, very quick, and gets out all the assets before the freezing order could hit? Is there any repercussions? Is there any opportunities that obviously you can trace where the money has been sent, that you can follow this up and withdraw that money, or issue any kind of freezing order to another company who saved those assets on the side as well?
No, I mean, potentially there wouldn't be essentially a freezing order because the assets have been dissipated, but you could potentially apply to set aside any transactions that undervalues later on. Normally when you've got judgments, so you could apply to set aside. They change the name of a property into the wife's name or the husband's name or a different company or a related company. You could apply and bring that other company or that other person into the proceedings to apply to set aside that order as a transaction that undervalue or transactions towards creditors or potential creditors. There are stuff you can do, but usually later on. And normally, we've had cases when we've got a judgment and there's been no risk of dissipation, no freezing order, but got the judgment, served it on, or the parties known about it, and they transferred a house usually from husband to wife, as an example. And then we would have to do a post-judgment freezing order called a Shabra injunction against the husband, who's part of the proceedings, but also, in this case, the wife.
Wow.
To freeze it, to make sure she does not then sell the house on to any third parties. But we would then have to bring a claim either within these proceedings or separately to show that was a transaction to breach to fraud creditors, or a transaction as an undervalue if they transferred for no consideration.
All right. I can see that there is no active question from the audience. So if anyone would like to join in and drop us some questions, that this is the opportunity to have a discussion with Edward, who is clearly an absolute professional in the subject. In the meantime, maybe we can have a look at the questions that we received previously. We talked about how to enforce a freezing order, I think, or is there anything else that you want to discuss?
No, I think, it's as I say, it's just make sure two things. One, to serve it on anyone, as you're saying, anyone who's not just the claimant, so not just the defendant or any party, but anyone who's holding the assets, or it's a bank or it's a third party, a nominee, serve it on everyone and anyone who's got a locus to those assets.
We discussed that, yes, they can still do. And what happens if you breach a freezing order? Yeah, obviously the financial institution is the one who is breaching it, so they also have to take responsibility. Yes, can you obtain a freezing order post-judgment?
Yeah, so that's what I was saying. So this is the case where the wife, we got the judgment, and we have to then bring proceedings against the wife as well to set aside that transaction.
All right. Yes, and can you still get a freezing order if you cannot provide the risk of dissipation of assets?
Yeah, this is what I was saying about the proprietary injunctions. If you can trace it's your assets, specifically your assets, that if it's some shares or etc., or you paid for those shares, if you can trace it, you can potentially apply for. It's not a freezing order, but it's a proprietary injunction, a similar injunction against that. But normally you probably apply for these two things at the same time. Normally, if you can show a freezing order and a proprietary injunction, and potentially a preservation order if it's a property, to make sure that property is not sold to anyone else.
Clear. All right. I think that was the last question. Edward, did we miss out something? Is there something that you feel that we still need to talk about? Is there any other element that you want to mention?
No, I mean, as I say, it's this summarizes just, I think, when you're applying for freezing order or considering that your clients, whether the freezing order is to get fast, get the evidence in best state as possible, and make sure you've got a strategy in place to enforce it, and if it's assets in different jurisdictions, and sometimes you might need to get someone involved, like a private investigator or someone, or tracing element, to make sure you could get that evidence, because it's not always handed on the plate to you. But just a suspicion of dissipating of assets is not going to be good enough. It's to have good cogent evidence of that. So make sure you act fast, and make sure you advise, and make sure you obviously advise clients about repercussions if you don't get it, or you do get it, and how to monitor it.
I've learned so much today. I'm sure that the audience also enjoyed this webinar at least as much as I did, because I think it was absolutely fantastic. It again just raises awareness of the risks which could happen, and we need to calculate with those, and it alerts us about opportunities as well, that what kind of legal opportunities we have in case that we are the victim of this, that there are opportunities to, even before the court order hits, there are ways to secure that whoever did a fraud on you, then you have an opportunity to get back that asset. So thank you very much, Edward, to be with us here today. And if you want to mention where people can find you, if they want to have more information on the subject.
Yeah, I mean, feel free. I think if you put my details back up, I think it's on the slides. If anyone's got any questions, they want to email me. There's Edward Miller at Madison Legal .co.uk. The details there. Happy to any questions, just drop me an email.
Amazing. Well, thank you so much. Feel free to reach out to us and give us more insights of what are the other topics that you would be interested. Thank you so much, Edward, and thank you for everyone who joined us today.
No problem. Thanks a lot. Thank you.
Thank you.